Good evening. In this session, we are going to discuss one question and answer which may be very important for the forthcoming main examination. This question is related to a recently delivered judgment by Honorable Supreme Court of India. This judgment is related to center-state relations. This judgment is related to the interpretation of the Constitution, interpretation of the 7th schedule of the Constitution by the Honorable Supreme Court of India. That's the reason why this may be a possible question in the forthcoming main examination this year. And this judgment is delivered very recently. This has been delivered in the month of July 2024. Regarding that, we are going to discuss. But before we go ahead, I would like to show you the question. Let's read the question and understand the question. Then we'll go for the discussion on this question and how to write answer for this. Look at this. The Supreme Court in its recent judgment said that the states have unlimited right to tax mineral rich lands. If you look at India, it's a very vast area and there are so many mineral rich lands that are present in various states in India. And whenever you hand over these mineral rich lands to someone for the purpose of exploration, who has the power to impose the taxes? Imposing the tax on mineral rich land, whose power is that? All these days it was an issue between the central and state government. This is a long pending case with the Supreme Court of India, and finally the Supreme Court has delivered its judgment, and the judgment was delivered in favor of the states. Very important. And that is the reason why in the recent judgment, Honorable Supreme Court made it very clear that the states have unlimited right to tax mineral rich lands. Otherwise, all these years, central government, by quoting a particular law that was passed by the parliament long back, and the central government saying the imposition of tax lies with the parliament. But the Honorable Supreme Court said it very clearly, that goes to the states. States have the exclusive right. States have the unlimited right to tax the mineral rich lands. This particular judgment, meaning this freed states from the restrictions imposed by central government, is in tune with the federalistic principles of governance. Very important one. And they have given a statement and we have been asked to comment. We know what is the meaning of the word comment. Make this statement as clear as possible. Kindly remember, this is the question. If it is asked in the forthcoming main examination, you must refer to the latest judgment that is delivered by the Honorable Supreme Court. That is the reason why I always tell you to read the newspaper every day. Even on the day of the examination, you are requested, you are suggested to read the newspaper, then head towards the examination center. Clear? So this is, one question. Otherwise, it may also be asked like this: are dilution in the taxing powers of the state legislatures will necessarily impact their ability to raise revenues? We know that under the Constitution of India, large amounts of taxes can be imposed and collected by the central government of India. Of course, state governments are also permitted to impose and collect the taxes. But comparatively, the amount of money, that is the revenue generated by the states, are very much limited. And when the enhancement of revenue itself is limited, then how can the central government will take away the rights of the states that have been provided by the Constitution of India with respect to the imposition of taxes on mineral rich lands? Look at this. So this will impact their ability to raise revenues. which in turn will impede their ability to deliver welfare schemes and services to the people. So obviously, every government must look after the welfare of the people. That is the reason why every state announces a large number of welfare schemes. And in order to implement those schemes, you need revenue. So the revenue is limited. And again, from this limited revenue, you want to take away something, the central government. That is the reason why, so that will, if you take away the rights of the states with respect to the imposition of taxes on mineral rich lands, that will affect the welfare mechanism imposed by the states at the state level. Clear? Now, right, this is the statement that is given. So you have been asked to comment in the light of the recent judgment by the Apex Court of India on states' unlimited rights to tax mineral rich lands. Statement is given and you have been asked to comment on this one. And the question is very, very clear. You have been asked to comment based on the recent judgment delivered by the Honorable Supreme Court. That is the reason why you have to read question thoroughly. By referring to the latest judgment, you can go for writing the answer. Am I clear? So then what are you going to write? How are you going to write? In order to write this particular answer for this question, what you should know? Let me tell you first. Look at this. First of all, one should know the meaning of the word comment, which we already know. Right? And in order to comment on this particular statements given in the examination, you should know the background of this particular case. Clear? Number one. Number two, you should also know the articles related. The articles related, those are mentioned in the Constitution, that you must be aware of this one. Plus, you should know about the 7th schedule of the Constitution, which mentions the 3 lists: union list, state list, and concurrent list. Here, the controversy is that central government wants to go by the union list and the state government wants to go by the state list. At the same time, central government also wants to interfere into the entry 50 of the state list. This is causing all the problem. I'll tell you all these things. And you should also know what is the Constitution bench. Many times I told you that Constitution bench is constituted by the Supreme Court in order to look into the constitutional issues. Clear? And also remember, Constitution bench constitutes minimum 5 judges. Minimum 5 judges. And in this case, the Constitution bench constituted 9 judges. 9 judges. And the verdict has been delivered in favor of the states by 8:1. Meaning 8 judges out of this 9, so they have supported the states and 1 judge has given a different judgment. Am I clear? Now, so you should also be very clear with the latest judgment related to this question, this particular issue by the Supreme Court. So once you are clear with all these things, you are ready to write the answer. Now you are ready to, your pen is ready to hit the paper. Now, so what are you going to write on this one? Look at this. Look at this very closely, my dear friends. Look at this. So because the question is asking about the, in the light of the recent judgment by the Supreme Court, a significant judgment delivered in a 8:1 ratio by a 9-judge Constitution bench headed by the CJI on July 25th, 2024, held that the power of state legislatures to tax mining lands and quarries is not limited by the Parliament's MMDR Act. MMDR stands for Mines and Minerals Development and Regulations Act of 1957. Now, if you look at the state list, right, so which is mentioned in the 7th schedule of the Constitution. So there are so many entries in the state list. There are so many entries in the central list and also in the concurrent list. We already know that one. So when you look at the central, the state list, entry 49, entry 50 are coming into picture. According to entry 49, the states have been provided with the power to impose the tax on mineral rich lands. No problem with this. But the central government is referring to entry 50 of the state list, and that particular entry, entry 50 of the state list is mentioning that, so whatever you are planning under 49, under entry 49, that can be restricted and limited by the parliaments. So by taking the advantage of this particular entry 50, the parliament started arguing, the central government started arguing that imposition of the taxes on mineral rich lands is the sole authority of the central government. But after the effective, this interpretation by the Supreme Court of India, the judgment has been given in favor of the states. Clear? So meaning, after this particular judgment, the states are very much empowered to impose taxes on the mineral rich lands, and they can collect those taxes. Clear? Right, look at this. The judgment said that the state legislatures derive their power to tax mines and quarries under Article 246. Please remember this one very clearly. What is Article 246? We have discussed very effectively during our Indian polity and constitution classes. And that Article 246 should be read with entry 49. Entry 49 in the state list, that mentions about the tax on lands and buildings in the state list of the 7th schedule of the Constitution. That's it. So your understanding should be so clear here. Since you are very much aware of the Constitution, since you read all the articles in the Constitution, you have to mention this very clearly. Supreme Court to deliver the judgment in favor of the states after referring to the Article 246, that should be read with the entry 49 of list 2 of the Constitution of India. That's it. Clear? So once you write this one, your answer is going to be very effectively presented answer. Now look at this. Mineral bearings. So what is the conclusion? How the Supreme Court has interfered this? How the Supreme Court has interpreted this? Mineral bearing lands fall within the description of the lands in entry 49. This is what is observed by, what is effectively interpreted by the Honorable Supreme Court. Clear? So mineral bearing lands, they fall within the description of the lands that are mentioned under entry 49. The majority judgment said that the parliament, through the MMDR Act, just now I told you, Mines and Minerals Development and Regulation Act of 1957. So the court said that through MMDR Act, Parliament cannot limit the power of the state legislature on the taxation of mines and quarries within their jurisdiction. So obviously the mines and quarries are under the jurisdiction of the states. By passing MMDR Act, the Parliament cannot restrict the powers of the states. This is what is observed by the Honorable Supreme Court. But the central government said that during its argument, the entry 50 in the state list, remember very clearly, if it is a question, you have to mention Article 246, you have to mention entry 49, you have to mention entry 50 of the state list. And you should also mention regarding, because the question is related to a judgment, constitution bench. So you should mention about the 8:1 majority. Clear? Then only the answer will be perfect. Look at this. Will be allowed to Parliament impose any limitation on taxes on mineral rights through laws relating to mineral development, in this case the MMDR Act. The central government has argued that under entry 50, the parliament has the power to impose the limitations, and the central government got those limitations by passing an act in the parliament, and that act is the MMDR. But Supreme Court has denied all the arguments by the central government and supported the state governments with respect to imposing the taxes on mineral rich lands. Look at this. However, the Chief Justice responded in the judgment to the argument by noting that entries 50 and 49 in the state list both, right, deal with distinct subject matters and operate in different fields. Very important. So, right, so the entry 49 is mentioning about the who has the ownership of the lands. Obviously that is the states. But when it comes to entry 50, parliament may impose certain limitations, only limitations, but you cannot ban or bar the states from imposing the taxes. This is what has been observed by Honorable Chief Justice of India. The limitations imposed by the parliament in an act like MMDR Act related to the mineral development did not operate on or influence state taxation of mining lands under 49, entry 49 in the state list, merely for the reason that there is no specific stipulation in the constitution to that effect. That's it. By observing so deeply, the Honorable Supreme Court has given the judgment, and as I told you, that judgment is in favor of the states. But kindly remember, what should be the beginning, what are the articles, what are the entries of the various lists that you are supposed to mention, right? That I have already discussed with you. So immediately after the completion of the class, I want you to, write down the answer without fail. Look at this. Entry 50 of the state list does not constitute an exception. The power to tax mineral rights vests in the state legislatures. This is what is said by the Supreme Court. The parliament does not have the legislative competence to tax mineral rights with entry 54 of the union list, right? So in union list you have another entry by 54, and that says that regulation of mines and mineral developments declared by parliament to be expedient in the public interest. This is what is referred by the central government. But the Supreme Court made it very clear by referring to the various entries, by referring to the various acts. Parliament cannot take away the powers of the state legislatures, and that power vests with the state legislatures only, right? And whatever is mentioned under entry 54 we have discussed, that is only a general entry, but central government is taking very seriously, and you have passed MMDR Act and you are taking the rights of the states, clear, and which is not acceptable. Power to tax mineral rights is enumerated in the list 2, meaning state list. The parliament cannot use its residuary power with respect to those subject matters. Very important. These are all the points that you are supposed to mention in the examination and give a conclusion very effectively to suit your observation with respect to the judgment delivered by the Honorable Supreme Court, and that will fetch you wonderful marks. Fine. So thank you so much, and I wish you all very good luck.